All right, everyone. Welcome to our live Q&A with attorney Yvonne Costelloe. We're taking Social Security questions today, so if you're interested in something with Social Security, please don't hesitate to make a comment, and we'll try to answer that as quickly as possible. Yvonne's been with us for quite a while now, 7 years if I'm not mistaken.
It's going to be six this
6
spring.
years.
Yep.
And you've only been a Social Security attorney, right? It's been like your whole career?
Well, for legal purposes, yeah. I've worked solely with Jen Dills as a Social Security disability attorney.
Where'd you go to school?
I went to law school at the University of Dayton School of Law, and then undergrad I went to Mercyhurst University, which is in Erie, Pennsylvania.
What is it that, like, I know you're passionate. I think every one of your clients would say you're passionate about Social Security, and you could have chosen any type of law. What made you decide Social Security was the way to go?
I came from a background working a lot with social services, working with developmentally disabled, dual diagnosis in the mental health field, community outreach, and I really enjoyed it. I enjoyed helping people in their everyday lives, working directly with them, and so an opportunity like this to be able to hopefully step up and really help people financially, bring in that income and who are deserving. It's just a great fit for me. I'm able to do more for the same type of individuals and help get the benefits that they really deserve and that they need for them and their families.
Oh, awesome. I think we can agree that a lot of people, in our firm especially, are just driven to help people. That's why we have some people who stay here for so long. So once again, if you have a question about Social Security, do not hesitate to put it down in the comments. We're going to try to answer as many questions as we can today. And we do have a few that were submitted ahead of time. And since Yvonne's an attorney, we haven't actually done a Q&A with one of our attorneys yet. I personally want to know, what can someone expect when they go to a hearing? What's it like? What's the dynamic there? Is it like what they see on Judge Judy, or is it completely different?
It's funny you say that, because the first thing I say to almost every one of my clients when we talk about what to expect is not Judge Judy. This isn't the people's court. That's kind of my citation with everything. This isn't what you think when you watch TV or you watch movies. It's more of a conference. There's two different ways the hearing will take place. It'll either be by video, where you'll go into a room, like a conference room, and when you go in, there'll be a big flat screen TV, and the judge will be on the TV screen, and he may have his expert on there, or the expert will be by phone. And then you'll be in a room with your attorney, and then also with a court reporter, a hearing reporter. And that person's job is really solely just to record the hearing. They won't ask anything, and then everything will go by video. Or if you're in person, if you're at one of the locations like in Charleston, or in Dayton, or in one of the locations where there is a hearing office, then you'll be in person with the judge, and it'll be you, the judge, your attorney, and then the vocational expert. When you go in, there is some formalities. You have to swear in. They'll have you raise your right hand, swear in that you're going to tell the truth. This is a court hearing, so you have to be honest. And then from there, every judge is a little bit different. Most of the time, an attorney will have an opportunity to make an opening statement, talk a little bit about what to expect, or talk a little bit about your record, and argue the outline of what's going on in your situation and your case. From there, most judges will either have the attorney ask questions, or you'll ask questions, or they'll ask questions. And those will be things that you'll talk about at the pre-hearing. They want to know how your conditions affect you. They want to hear it directly from your mouth, and how your pain affects you, or how your mental health symptoms impact your daily activities. Do you have a hard time standing or walking? Are you unable to engage with activities with your family? And a lot of that we talk with the clients ahead of time at the pre-hearing, and that's why sometimes the pre-hearing is a bit challenging, but that's why we do it. We want to ask you those hard questions when it's just you and I on the phone or in person, so you know what to expect. And then from there, the judge may have some follow-up, or the attorney may have some follow-up, and then we go to the vocational expert. Sometimes there's medical experts at a hearing, and they're not going to examine you during the hearing or ask you any questions, but they're going to go through and they'll have looked at your medical records and make an opinion about what they see in the medical records to help the judge and your attorney. The vocational expert is going to testify about jobs. In order to be found disabled, in pretty much every case, we have to prove that you can't do any work in the economy. So it's not like other claims like workers' comp, where maybe you just have to prove that you can't do the work you used to do. We have to get rid of all jobs. And that's why the vocational expert's there. And so the judge and the attorney will ask them what's called hypotheticals. So they'll say, for example, John, if you were going into a hearing and maybe you had an amputation, you had lost an arm in an accident or something, then a hypothetical could be, if we had somebody of the same age and education as John, the claimant, and they lost a limb, is there jobs they could perform? And then the vocational expert will say yes or no. And if they say yes, they'll give examples. And that's the most confusing part of the hearing for most people, because they're listing numbers and jobs and they've never heard of these jobs before. But your attorney is well equipped to handle that and will handle it. They're not going to expect you to respond to that. At the very end, the judge may give an opportunity to close out and make a closing. Some do, some don't. Every judge is different. But then the one thing that's most important that most people are not aware of coming in is that you don't get a decision that day. The attorney may have an inclination of what's going to happen, or the judge may say, yeah, I think I'm going to find you disabled, but nothing's final till it comes in writing. We always, even when a judge says in the hearing that, yes, you are going to be found disabled, or I am going to find you favorably, I still tell the client, I give you a 99.9 because we want to get it in writing. We want to see it come in the mail. Mm-hmm. And usually that takes 30 to 60 days. It can take up to 4 months after the hearing is over. So that's pretty much kind of in a nutshell how it goes and what to expect, but definitely not like the People's Court. There's no yelling or gavel slamming or anything like that going on.
And they most likely don't receive a judgment that day, correct?
Exactly, yeah. We expect it to come in writing, and so even if the judge does say they're going to find you disabled, we still have to get it in writing because it's not final until it comes in writing.
Okay. One of the other questions we ask quite a bit is about grid rules. And I've done some personal research about this, and I personally find it confusing. I know a lot of our clients, I believe, find it confusing as well. Can you describe what grid rules are and how they affect Social Security?
Right. So the grid rules are a special set of regulations that come into play because the Social Security Office or the administration takes into consideration your age, your education, and the type of work you used to do. Mm-hmm. Technically, the grid rules can apply when you're young, but they're not helpful until you're generally about 50 years old. I always tell clients that generally 50 and 55 are the magic numbers where a lot of things can change. There's some exceptions to that, and that's getting a little complicated. Mm-hmm. But what starts to happen is when you turn 50 and then when you turn 55, they start to recognize that you don't have the same ability to step back into certain types of work. So what they'll look at is they'll look at your age, the type of education you have will affect you, if you have a high school diploma or not, or if you have a college degree or not, and then the type of work you used to do. And this becomes a big issue, or really comes into play a lot of times when I have clients that change age categories. So you go from being 49 to 50, or you go from being 54 to 55. That can make a huge difference in your claim. So for example, if I have somebody that's, let's say 48 when they apply for benefits, and their past work, they did all heavy work. We'll say they're a coal miner. We work with a lot of coal miners. They've only ever been a coal miner. And Social Security said, okay, we know you've only been a coal miner, but we think you can do sit-down work. We know you've got some back issues and neck issues, but you can do sit-down work. Well, maybe by the time they get to hearing, they've turned 50. At that point, they may then be found disabled because Social Security doesn't expect a 50-year-old who's never done sit-down work or never had a job where there's skills they can do that would be equivalent to sit-down work, and they're limited to sit-down work. They understand that you're going to have a really difficult time finding a sit-down job, and so if that's the situation, you can be found disabled. And I think that comes up a lot when I have clients say, okay, you changed age categories, or sometimes judges will offer to say, listen, I think you're disabled, but I don't think you became disabled till you turned 55. And that's really confusing, but that's because of those grid rules, and they're very powerful, and it's one of the more solid aspects of the disability claim where we can say, hey, this and this apply, and therefore this person should be found disabled. But that's why age is so important and can make such a big difference, especially if you're changing age categories during your claim.
One thing I think a lot of people don't realize is how complicated Social Security is as a whole. One thing is, if it was easy, everyone would do it.
Yes.
And if it was easy, it wouldn't take so long. We do have a quick question from one of our audience members, Mr. Davis. And you may not know the answer to this, but you know how people get a statement from Social Security every year saying if you became disabled this year, you would make X amount of dollars.
Correct.
He wants to know if those are completely accurate and how much they come into play.
They're pretty accurate. So when we look at somebody that is Title II eligible, meaning that they've worked and they've paid into Social Security, they've paid taxes, they're building up almost like an insurance plan where if they become disabled, they're going to get paid back. And the more you pay into it, I guess the more you make and the longer you work, the more you're going to be able to get back from that. I think the maximum is $2,500 or $2,600. And what happens is when they send you that statement, that's what I always tell clients is it's a rough estimate. So it's what happens is if you're found disabled, they do go back and recalculate and make sure everything's correct. But generally, it's going to be really, really close to that number. It does go up a little bit each year due to cost of living and things like that and adjustments. But pretty much that's pretty much about what you're going to expect, somewhere very close to that range.
And I think that probably goes back to because everyone's paying into the Social Security tax each year, and they base it off of that. It's not just they're not just pulling anything.
Nope, it's based on your work history and also how much you're making. So the only time I've really seen people come out and get a $25 or $26, I think $2,500. We call it the PIA, is when they've made significant earnings over an extended period of time.
Okay. Mr. Davis, thank you so much for your question.
Yes, thank you.
If anyone else has a question, please do not hesitate whatsoever to chime in. We got our iPhones here, our watches and everything, so we can catch your questions. One thing I want to ask you, just because I'm always thrown off by the alphabet soup that is Social Security, and I'm sure if we have anyone who's getting VA disability watching, same problem there is like all these acronyms confuse you.
Yes.
So there's two things that you'll see, almost everyone will see in a case. That's an ALJ and a DE or disability examiner, and of course ALJ is administrative law judge. What's the difference between those two? Because they have similar jobs, correct?
Well, kind of. So when we're looking at a disability examiner, that's somebody that generally is just looking at the opinions that are made by the doctors. So when you apply for disability, what Social Security will do is send your medical records to one of their examiners who will review it, and they'll make an opinion. So sometimes clients say, oh, I got a decision and they're talking about Dr. Joe, and I don't know who Dr. Joe is, I never saw him. And that's usually one of the doctors that Social Security has review your case. And what'll happen then is they'll review that, they'll have a vocational specialist who will review your work history, and then the examiners come in and they'll make a decision on what your capacity is based on those two things combined on whether or not a finding of disability should be established. The difference between them and an ALJ is an administrative law judge is the one that you're actually going to go in front of with your attorney. Most of the time you don't go in front of a disability examiner, but with the ALJ, they're not bound by the prior decisions. They're going to make their own independent decisions. So although those decisions are there, they don't have to follow them. They're also going to have additional evidence. And also when you're before an ALJ, that's the first time your attorney has an opportunity to really discuss the medical records with the judge, to make comments about what was found by them. Oftentimes when I look back, the first step I always do in finding if a client's disabled is to look at, well, what happened? Why did they get denied? And you can't, that's the first way of moving forward is, you got to plug the holes in the boat is what I always say. So I look for those holes. Why did this client get denied? And then is that accurate? And to look back and say, hey, Your Honor, I understand that they found this, but that's not correct, or we have this new information. And the ALJ is able to make those determinations. And the ALJ determination is really more final. At that point, then we're looking at appealing up to the Appeals Council or Federal District Court after that.
Awesome. Thank you for that, for sure. Once again, anyone, if you have questions, please don't hesitate to ask. See, we have several people watching right now. Thanks to everyone who's tuned in. We do have a few more questions to ask Ms. Costelloe here, though. One thing that we've discussed a lot downstairs, and by that, I mean, if you're not in the office, Social Security is downstairs mostly, and VA is upstairs. Auxiliary benefits. I hear that word thrown around quite a bit, especially like after people get approved, but I think if you're not in the system, you might not know what auxiliary benefits are. Can you describe that to us?
So auxiliary, and the question leads in perfectly when the gentleman earlier was asking about the amount that they'd get paid. What happens is there's two amounts. There's one amount that's kind of the individual PIA, and then there's something called a family max. And he may have seen that on his statement if he was looking at it. The family max, the difference between those two is the auxiliary benefit amount. And what happens at that point is if you have a child that's a minor, and by minor we mean a child that's under the age of 18 or they are up to age 19 and still in high school, then they can qualify to get these auxiliary benefits. It's essentially divided evenly between all your dependent children. So if you have 10 dependent children or one dependent child, it's the equal amount, and that is divided evenly between those children. There is times where stepchildren and some other situations can also be qualified, and that's kind of an individual situation that we can address if need be. But that amount would be distributed if the child essentially is distributed to the child's caretaker. So if the child is in home, then it would come into the home, or if the child is living in a separate residence, then whoever that child's guardian or custodial parent is. And that is just another way for them to understand, or for, I guess, Social Security to understand that there needs to be additional funds for that minor child.
Okay.
And that's essentially what auxiliary benefits, what they do for your family and the eligibility of those.
Okay, great. Donna has an interesting question. Donna, thanks for commenting. So when she says that she received her first check on December 1st, obviously she's approved, and congratulations on that. So she received her first check December 1st. She has not received her back pay yet. So on average, how long does it take for an individual to receive back pay?
So back pay is done on two different levels. If somebody is going to get SSI back pay, that's generally done at the state level. And if they're getting SSDI back pay, and I know this is getting a little complicated, then that's generally done at the federal level. So it just depends on how fast. Usually somebody's going to have their back pay by the time they get their first payment. And if there's a delay, then there can be a couple different reasons why. It could be that there's some type of processing issue, or it could be that there could be a lien or something like that could be affecting it. The best thing to do is if you've started getting your payments and you're still wondering where that's at, you can certainly contact our office, and there's often times where there are delays, and our case managers will work directly with you to see why there's delays and what we can do. But generally, you should see your back pay. I think it's generally up to 120 days after your decision is pretty typical. But again, things happen, and it wouldn't be, and that's what we're, again, still here for you, still here to work with you, even though we've been able to get you a favorable decision. We do continue to work with you, and our case managers are excellent at that. So Donna, if the best thing I would suggest is if it's been more than that, contact your case manager and discuss that with them, and they can certainly look into that for you, no problem at all.
And one thing we always have to remember, sometimes mistakes get made on Social Security's end.
I could never been heard of, John. Yeah, that it does happen, and that's what, and we continue, and that's all included in our representation. We're not going to send you a separate bill or anything for that. So certainly call in, and we'll work with you and see what's
We
going on.
apologize about the technical difficulties there. Of course, when you have a Social Security claim, you're going to have all kinds of issues along the way. So this is no different. We're used to little hiccups along the way. We have one last question we wanted to ask, and Yvonne wanted to ask it, or just explain in more detail. Why is the backlog taking so long for so many people?
And that's a big one. That's the biggest complaint from every single client, and not just from the clients, but for us as the representatives, and the frustration of it is that it does take a long time. On general, the average wait time from a hearing is about 600 plus days, and that's nationwide. And a lot of that has to do with the administration. And I think it's really important to clarify that it's not your firm that's, and especially for us, it's not us that we're not ready to go and we're not willing to go. It's a matter of getting Social Security to get those hearings scheduled. Jan and everyone in the firm has been great about making sure that we have attorneys ready to go and ready to participate in these hearings. But what happens is they currently have a backlog with regard to hiring, for the judges and for those that need to process the claim in the administration. And they also have a budget that really hasn't changed, from my understanding. And so there's a lot of complications there. The Social Security office is the one that decides when the hearings are generally going to be scheduled. And the hearings are pretty much scheduled based on, for the most part, your application date and your initial reconsideration determinations. There's some exceptions to that, and there are some opportunities where we can try to get that sped up. We do everything we can internally as attorneys for our claimants, that if we think that somebody meets special requirements, either because of the dire need, it's called dire need application, where there's issues of homelessness or bills being shut off, we try to get those processed. Or if somebody has a condition that meets a certain level of severity. Now, every one of our clients has severe, significant medical issues they're going through, but in some circumstances where that person has certain criteria, Social Security has something called a book of listing, and in some circumstances where somebody has a very, very cut and dry condition, if they have cancer that's metastasized, or if they have certain findings on a pulmonary function test, or sometimes things of those natures, we will try to get those approved ahead of time as well. But other than that, in general, it is taking up to 2 years in some cases, if not longer. Same thing with the Appeals Council. If they just go in the order that they're received, and the administration has to process those applications and has to prep those cases to a certain point before they'll even approach us about getting it scheduled. But we generally, one of the good things about the way our firm functions and the way the support staff that we have here is once they say we're ready to schedule, we're generally ready to schedule. We take those hearings and we do everything we can to make sure that we have attorneys available in a wide variety of areas to make sure that we can get those clients up and running when their hearing's scheduled. We always make sure that we can get there and make sure that's taken care of. And I think we've done an excellent job of that as a firm and making sure people getting in there and doing everything we can to make sure we're 100% ready to go. And the important part about that, for anybody watching, and if you're watching, you're probably not going to be the one that might have issues with this, is staying in communication with us, because once we get that hearing, once we get the hearing date scheduled, we know generally before you do, and that's when things really start moving fast. We have a special development team that's going to make sure we have all your medical records before you even talk to your attorney. There's a lot of different wheels that start moving very fast. But for the most part, the frustration is with the agency, and I want people to really understand that the attorneys that are out there, and if another attorney promises you that they can get in a hearing faster, generally that's not going to be accurate, and I think that's a big misconception that floats around of why that wait time is the way it is. But I certainly think it's really unfair, especially given the circumstances and what individuals are facing when they're waiting for their application. This isn't an easy time. This is a time when people are undergoing significant financial issues, they have massive health issues, and they're facing this added stress of not having a determination or decision on their case. And it's really unfair, but we're going to do everything we can, to speed that up the way we can, or in any way that we could, and make sure that when it comes time for you to go to your hearing, that we have everything lined up, ready to go, and ready to get everything moving at that point.
Okay, and Mr. Davis had another question, and I can fill this one. He wanted to know once he gets approved if he can file for VA disability, and that's, we're happy to give a consultation for that for sure. We have the staff here that's prepared to answer that question. There's no general yes or no. We always like to take everyone on a case by case basis. So just be sure to give us a call at that point, and we'd be happy to give you that consultation, and we might be able to help you with that.
And we have a lot of clients that have both claims moving at once, or I handle a lot of clients where we've gotten their VA disability approved, and now we're working on their Social Security disability. Those are kind of two different beasts, but certainly if you have questions, we have a great intake team that can answer those questions, and we'll be able to address that.
Awesome. Well, everyone, thank you so much for tuning in today. For those who asked questions, we appreciate it. We'll be doing this again in February, so look for a date and time soon. And once again, thanks so much for watching. Have a good day.